A very good evening, dear esteemed viewer, and welcome to our today's edition of Citizens and the Law. Citizens and the Law is a program aimed at demystifying all issues standing as strange before the gullible heads and laypersons towards the knowledge of their rights, defense of these rights, and becoming law-abiding citizens. In our today's edition of Citizens and the Law, we are going to look at landlord and tenant rights in Nigeria. Are the landlord injured or are the tenants injured? Who is actually at fault? It is a kind of crisscross accusation. And here today I have in the studio to do justice to today's topic vis-a-vis provision of answers to all the questions by getting the I's and T's dotted and crossed. I have Barrister Zioma L. Okonkwo by my immediate right. Counsel, you're welcome to the studio.
Thank you, sir.
And at the other end, I have a very good friend in the legal profession. I am talking about Barrister Larry Emeka Nwangu. He's also here to ensure progress of the program. Counsel, you're welcome to the studio.
Good evening, presenter.
And I am the presenter of the program. Jude Mascot Obiagu is my name. Okay, ladies and gentlemen, let's just get started doing justice to this topic of the day. The topic is landlord and tenant rights in Nigeria. Tenants do not pay their rents. Landlord do not repair the building when necessary. Right or wrong, I do not know. This gentleman and lady that are here to tell me which is which. And I want to get started with Barrister Zioma L. Okonkwo. I want you to tell us something. Who is a tenant?
Well, literally, a tenant is a person who is in occupation or possession of another person's land or property, basically based on rent and with regards to binding oral or written agreements. As far as you're in possession or occupation of a thing not yours, you're a tenant. That is the literal definition of a tenant.
As regards to legal or written agreements?
Yes.
Okay, you hold that. I'm coming back to you. Counsel Larry Emeka Nwangu, who is a tenant?
Actually, that word tenant also does include a subtenant. And it equally denotes any person either in possession, either paying rent or not paying rent. And a tenant can also include a subservient or service tenant. They can also be regarded as a tenant. And a statutory tenant also is a tenant in law. But a licensee within the meaning of the recovery of tenant law is not a tenant. So this is the way the law looks at it and the way the law classifies it. Just like a person who is actually in occupation on bona fide claim of right of ownership, such a person can never be regarded as a tenant. So these are some of the exceptions, with regard to that definition.
Okay, now let us look at this word, legal or written documents. Some tenants have legal or written or all of the above documents to legalize their occupation of the place. What about those who doesn't have anything like this? Are they not tenants?
They are tenants.
Okay.
Like I said, the agreement could be oral or it could be written. Okay. It could be an oral agreement, it could be written. But most of the times it's advisable that you go for a written agreement in order to legalize that.
Does oral agreement hold water at all, Larry Nwangu?
Yes. From the definition, I say that any person in possession, so, whether paying rent or not paying rent. Whether you have a contract or you do not have a contract, contract is merely to spell out the terms of the tenancy. But so long as you are in possession of a premises, and you're not in that premises under the bona fide claim of right of ownership, you are a tenant.
So you could be a tenant in utmost good faith.
Yes.
Okay. Okay. Right now, in presence of this definition you've presented here, there is a tendency to have some violations, and this could take place on the hands or side of landlords and tenants. Hence, I want to ask you: we have bad landlords, we also have bad tenants. Who are they? Can you explain, Larry Mungu?
Well, when you choose to use that word, bad or good, but in law, it all amounts to maybe breach of certain rights and obligation, because even in oral or written agreement, in oral agreement there are presumed terms that are associated with that kind of understanding in tenancy. So also those agreements could be putting down in writing. So when you look at it, let me just say, for instance, the tenant, on the side of the tenant. A bad tenant can be seen as one who doesn't pay his rent as at when due, and who in the rented property, is involved in damage, malicious damage, to the property, to depreciate, from the standard in which the rented apartment, was given to him. You can see such a person as a bad tenant, and a tenant who is always in breach. For instance, a written agreement on that tenancy. You're always constantly in breach of some of those terms of the written agreement. You can be seen as a bad tenant. Then, on the side of the landlord, a landlord is obliged under the tenancy agreement to put the rented accommodation in habitable condition. A situation where the landlord, neglects his duty, only interested in collecting rent, and the property is dilapidating, depreciating every day. Structural damage is being observed in the rented apartment, and you keep mute, quiet, maybe waiting for the tenants, to repair it or effect the repair for you. You can be seen as a bad landlord, because these are obligations that inure to you within the ambit of the law and within maybe oral or written agreement between you and the tenant.
In the face of failure to repair damaged properties in where the tenants are living, this landlord is living in London, and he hired the services of estate managers. Who is to be blamed? The landlord still, or the estate manager?
Under maybe where an estate management, or we call them agents, or maybe a legal practitioner is in charge of the management and administration of the place. That person automatically, by the power of attorney donated to the agent or the solicitor, he becomes the landlord. He is now the landlord. That is the implication of that power of attorney. So whatever agreement that is entered between the tenant, it is actually with the legal practitioner or with the agent of the landlord, who is now the landlord, because that power of attorney makes him the landlord of that property in terms of management and administration, but not in terms of title, because the title still
belongs to the original owner. Okay, Ozioma, Council Ozioma, can you look at this landlord and tenants, good and bad?
Like you said, a good and bad tenant, a good tenant and also a bad tenant, a good landlord and also a good tenant. It depends on the tenancy agreement. Once you're in breach of, any of the parties is in breach of the agreement between the both of them, that means you are a bad landlord, you are a bad tenant. But once you're keeping to the agreement between you and the landlord, you're a good tenant, you're paying your rent as at when due, you are not a nuisance in the environment, in the premises, and then you are doing everything to keep the property of the landlord in good tenantable position, and the landlord is on his own part is also doing his part, giving you the quiet possession, quiet enjoyment which you deserve by paying that rent to him and renting his property.
Thank you, dear esteemed viewer. You are watching Citizens and the Law on ABS Television, Channel 24 Oka. If you want to call us, the lines are open. I can start receiving calls. The numbers are there on your screen, and that is 090 729 72090, 090 729 72090. The other line is 07062724192. I am calling it like this because the numbers are clearly written on your screen. If you want to call us in Igbo language, just to let us know about what problem you are having with your landlord, whether what the landlord is doing is right or wrong, legal or illegal. I have two lawyers here in the studio to address the question. All of them, both of them are Igbos, so you are free to make your calls. Before we continue, let's take a short break. Thank you very much. If you want to get us, you can call us on the numbers on the screen there. This is happening live on ABS Television, Channel 24 Oka. You can also get us on Star Times 113 and Metro Digital 29. I am coming forward now with the last question, and I'm going straight to Barrister Larry Emeka Nwangu. Is there any need to collect receipts? Does it really matter to have them after payment of your house rents? If so, why?
In normal life, generally, it is advisable for whatever purchase or service rendered to you that it is receipted as an evidence to show that such a thing transacted. So when it comes to tenancy, it's part of the rights that the tenant have. When you pay, you're entitled under the law to be issued a receipt as an evidence that you have paid. Because when it boils down to I paid, I did not pay, there won't be anything upon which maybe the court can look at to say that actually you paid for 2-3 months or you did not. So it is very, very essential and important that when a tenant pays, he deserves or she deserves to be issued a receipt. It's part of the right.
Because on landlords, when you go to them and pay, they bring out an exercise book. They'll just write their name and tip it good. You're okay for the month, you can go. So, cancel. How about that? I think that one can
yes, it mustn't be a printed receipt. It could be a written agreement or a note.
No, what I'm talking about is that the tenant doesn't go back home with any piece of paper. They just brought out an exercise book. Okay, they get to where a name is written in the particular month and tip it good. You are paid.
You have to give the tenant a copy of that your noted.
There is something we said, we passed it, but I want to go back to that, about agreement which should be written between the landlord and the tenant. This agreement at times is not in place. I just asked somebody and he was telling me that there was no agreement. I said, in utmost good faith, he said yes. Is this not dangerous to live in a house without an agreement between the landlord and the tenant? Councillor Zeman.
Like he said before, it is not dangerous.
To live in a house without agreement?
It is not dangerous based on the relationship between you and the landlord. But at times, the relationship can go sour, and that is when that written agreement is required.
Yeah.
But whereby there is no agreement, you are still a tenant. Yes. As far as you have your proof of payment of rent to the tenant, to the landlord, it still holds water.
Does it stop at that, Larry Wangu?
Actually,
as long as you pay your rent, it is enough.
Actually, agreement or without agreement, one who is in possession of a rented property is deemed under the law as a tenant. But then, I am of the view that agreements can clear some certain issues, because you might come into a rented apartment wherein the landlord expects that when, should I say, one of the zincs, you understand, poles, that you being the tenant should repair it. Are you getting it? So in such situations, these things need to be agreed upon. If they are put in black and white, the tenant will now know what rights and the limits of the right he has over the rented accommodation. And you can see a situation where some landlord, you might just be owing them a month's rent, and they will come and pull your roof, and rain will be falling on your properties. Written agreements can always guide all these things, because you never can tell when two people are exchanging words. We agreed this, we agreed that. What then will be, if it gets to litigation and before the court, the basis upon which the court can now say, yes, this is what invariably both of you agreed.
And there is this issue again, that even if there is disagreement between the landlord and the tenants within themselves, some years do have what I may call constitution, rules and regulation. This is the time we come in. At most 10 p.m., everybody should be in. If you are not in, then you have to call somebody, maybe within your flat, to come and open the gate for you. And again, people violate what I may call or understand as parking lots in the yard. A lot of internal laws within the tenants themselves. Is this supposed to be a part of the landlord-tenants agreement, or should it be inculcated into the agreement? Does it have to be respected by the agreement between the landlord and its tenants, respectively and generally, in a particular address?
Like some landlords prefer to inculcate those particular terms in the agreement. Most of the times it's good when it is in that agreement, so that you will know your stand in that premises. This is what you're supposed to do, and this is not what you're supposed to do. But where it is a rule between among everyone, every tenant in the premises, it is also binding on you to accept that terms of agreement. Because for the tenants to come together and say, okay, we want this, they must have discussed it, like the caretaker of the premises must have discussed it with the landlord himself, and the landlord will say, okay, go ahead, I give you a go ahead or that you should have a meeting and agree on it. As it stands, it's also binding between you and the landlord.
Let's come to this issue of quit notice. When is a quit notice said to be valid? As regards to right to valid quit notice before eviction? Can you look at this issue of quit notice? At times they said 7 days, at times they said 14 days. How should this be given? When is a quit notice said to be valid vis-a-vis right to valid quit notice before eviction? Larry Wangu.
Actually, the issue of quick notice, in fact, it was part of the reason why our law seems to be more tailored towards the tenant. It seems to protect the tenant more than the landlord, because of the nature of events that happened during the time which this law came into effect, especially in Lagos, where accommodation problem was very acute, and landlords could wake up one morning and throw your things on the street. So these were some of the things that the law came in to checkmate, to regulate the relationship between landlord and tenant, to also ensure that the landlord uses the procedure within the law in order to eject a tenant, and to also protect the landlord from tenant who is holding over, because once the tenancy is determined, a tenant, can be evicted. The notices required by law to be issued so that it will be procedural. If you do not do it that way, the whole process will amount to a nullity. One is quick notice. And this quick notice, when you issue it, there are certain laid down procedure, very meticulous procedure that you must follow, which has to do with the term of the kind of tenant. If such a person is a monthly tenant, weekly tenant, tenant at will, if such a person is a quarterly tenant, or half a year, or a yearly tenant.
It's spelled in the agreement.
The law has a way it takes care of it, and that notice must surely reflect those things. If it does not, then the whole process amounts to a nullity. So if a tenant is a monthly tenant, which also comes into...
Sorry for interruption. This very area is very important. I want us to enter into our Igbo language so that some people are feeling victimized. They're not getting us. Ife gbasalo landlord ekwapo ma chopo mmadụ n'ụlọ kedu otu esi eme dịka iwu si were kwu abịa nnọọ akwapụrụ onye afọ ife n'iro enwere usoro iwu a ga-esi mee ka o wee kwuo onye aha nghọta dịka isi ekwu onye na-akwụ ụgwọ nọ n'ọnwa onye na-akwụ n'ọnwa ịtọ ọnwa isii ofu afọ ka nwoke n'ife a gbarie ife a gbarie enwe obere n'asụsụ Igbo maka na ọkwara ndị Igbo ka anyị na-agwa ọ na-abụ ndị politishan pụta mgbe ụfọdụ fa na-agụrụ ndị Igbo ibe ha welcome address n'onu oyibo ka anyị gbekere nke a na Igbo nwe obere ka ma ndị be anyị ghọta ife a na-ekwu ọfụma ọtụtụ n'ime ofe adị anụsị ife anyị na-ekwu.
Ihe m na-akọwa bụ na n'iwu nwere otu o si wee kwado onye ọwụna bi n'ụlọ gị dịka tenant. Ọwụgodi na onye ahụ bi n'ụlọ gị nọ monthly ka ọ na-akwụ gị ụgwọ, ma ọ na ọ na-akwụ gị ụgwọ 6 months, ma ọ na ọ na-akwụ gị ụgwọ yearly. Iwu nwere otu o si wee kwado ọnwa isii ma ọ ofu afọ. Ọwụ na ọ na-akwụ gị ụgwọ n'ọnwa, ma ọ na ọ na-akwụ gị ụgwọ n'ọkara ọnwa isii, ma ọ na ọnwa isii, ma ọ na ofu afọ ka ọ na-akwụ gị ụgwọ. Iwu nwere otu o si wee kwado ị ga-esi wee nye ya akwụkwọ ị ga-eji wee chụpụ ya n'ụlọ, ọ ị ga-eji wee wepụ ya. Izizi wụ na ị ga-enye ya notice, ihe a na-akpọ quick notice n'olu oyibo. Ọwụ na ofu ọnwa ka o ji na-akwụ gị ụgwọ, ma ọkwa na otu gị na ya mere agree, maka agreement na the binding between the parties bara into it. So inye ya 1 month. Ọ bụrụkwanụ na ọwụ ọkara ọnwa isii ka ọkara ọnwa isii, that is ọnwa atọ, ịghọtara, onye ahụ ị ga-enyekwa ya ọnwa atọ. Ọ bụrụ na ọkara afọ ị ga-enyekwa ya ọnwa atọ. Ọ bụrụzie na afọ ị ga-enye onye ahụ ọnwa isii. Otu iwu si wee kwado ya. Ọ bụrụ na ime otu a, ihe niile ị mere erute n'ụlọ ikpe ekpochapụ ya, sị gị ga-abido n'isi. So ọ bụrụ onye gị na ya nwere agreement, ọ ya ka m ji asị na agreement dị mma ka o wee nwee ike na-akọwata. Ele anya na agreement a ga-ahụ ihe unu kwekọrịtara. Mana ọ bụrụ na onwe agreement n'ọnụ ka unu kwuru ya, ụlọ ikpe ga-achọ ihe ọ ga-eji, ihe ga-akwado ọ ga-eji wee nwee ike mana ma ọ wee eziokwu, maka landlord nwere ike isi na ofu ọnwa, gị nwa asị na ọnwa isii ka gị na ya kwuru a ga na-akwụ, ọ egwa mma agwa gị. ihe ụlọikpe ga-abịazile anya wụ kedu otu onye a si akwụ ụgwọ ọkwa ya wee ebe risiti a na-ekwu okwu bakwara uru maka ụlọikpe jụọ ajụjụ a enwere ike ise ọnwụ isii ka ị na-akwụ ụgwọ ngwa gosi m ihe iji ihe gosiri na ọnwụ isii ka ị na ma onwe nke ị wetara onwekwa ebe ụlọikpe ga-agbado nwụkwụ wee nwee ike sị n'otu a so ihe ndị a ụlọikpe jụ ha ajụjụ a ga-esi na ọnwụ isii ọ sị gị weta n'ihe ga-egosi na ọnwụ isii ka iji akwụ ụgwọ iweta ya ụlọikpe nwere ike ịgbagide ụkwụ ebe ahụ wee sị na ọnwụ isii ka onye a ji akwụ ụgwọ i were ofu ọnwa wee nye ya akwụkwọ oge eji apụ n'ihi nke a i mere ya na ị ga-ebido n'isi inyecha ya nke a maka ọ dị notice abụọ ọ dị very mandatory ọ dị very important inyecha ya nke a immediately inyechara ya nke a gịnị ya awụzighị landlord na tenant ịghọta ihe gbasara landlord na tenant ebigo ihe ewuzewu onye nwe ụlọ ya wa awụrụkwanụ onye ọkụpa ya ịghọtara ihe ọzọ iwu kwadoro na ị ga-emewu na ị ga-agwa ya si ya di anyị ebe tenancy agreement mụ na gị landlord and tenant relationship mụ na gị ebigo ebe m na-enyere gị akwụkwọ notice to quit na obigo ị ana m agwa gị ugbu a na ana m achọzi ịga gbaa gị akwụkwọ n'ụlọ ikpe wee chụpụ gị ị ga-agwa ya nke ahụ agwa with notice or 7 days ka ọ ga-alas after 7 days ahụzi ịgba ya akwụkwọ otu a ka ị ga-esi wee mee ya eruzie n'ụlọ ikpe anyị ga-erute ebe ahụ ma emechaa ka nkọwa otu a ga-esi were nwee ike lechaa ha anya wee kee ikpe. Ndewo.
Okay, still on ABS Television, Channel 2 for Oka on Citizens and the Law. Topic is landlord and tenant rights in Nigeria. And you can also get us on Star Times 113 or Metro Digital 29. A break, we shall come back quickly. Well, dear viewer, in respect to this very topic, we went to town and sampled people's opinions, the landlords, the tenants, and I think a politician who is also a tenant. I couldn't get at any lawyer because they are here in the studio with me. So I welcome you to those clips of what I will call a vox pop.
na-afụ n'ọlụlụ n'ebe ahụ ka anyị esi were ụbọchị mkpa niile doro ya n'ụwa chefuzie na ọ bụrụ na ife ọ na-eme anaghị aga o nwere ego na-akwụ ya n'ụlọ anwa ga-ezuru ya na ndụmọdụ na-adaga landlord bụ ekpere ka ife ị na-eme na-aga ka nke onye mbeghị na-eme na-aga ka o wee zụta wee kwụọ ụgwọ ụlọ ebe bụrụ aja mgbere adọrọ ife na-ebe ebe oke na-ebe ogene ọ kasịra keta ọnọdụ Naijiria na-etu ọdụ eji ọzọ mgbakpọ mgbere gbanụcha afọ n'alụ daalụ ife na n'ụgbọ na landlord na-ewe akara aka ha ewepụrụ aka ekwenyesịrọ nna ya ụfọdụ ndị mmadụ na-apụta ọ bụrụ na ife o ji azụ afịa na-akpọkọta ya azụ afịa ụmụ ikorobịa ụfọdụ ọ bụrụ ife o ji azụ afịa dịka ebe 1 million On my care about 250,000, 3,000, they pull no for 800,000 or 700,000 naira. Or for the issue, I went to 400 and then. Also, as I each 1 million as well, she got to 500. I go through with them back. Wow, very expensive. Oh, yes, a lot of jack like I bet on Bella not to do now.
No.
Mrs. Nega of the different HM Udingo, Akamba. This is the Deka, what they got at a window. Of what will be billion window. Who was for Rosia, Ecozo, yes. Before the Bundiga and Apozoba, at a Faposeko, in a wafa, or they believe our and a day bath, or other on their bath, a room and their bath late, or their bath. Then never see or Uzia, to the regiment of landlord. But I'm going to have Bazia Gabaki, our landlord in the roof, who will tell us so soon. I have to get it, so I will do so and they waited from the tenancy. For the ball of Fajibata, and she went out a billion. On the phone, and then you for the Bundigan or there. Name me fair with it to be made of my town at Rafa. I'm going to say anything. I may make a family as well. No for the one. Ndahana or Harali and let can tenant Yafu, which are done, we say, no family and say. But an offer when I both father, you take action in those tenants Yafu. You have to report how much always supposed to have a seat when you name tenant Yaha. The way you can hold your mobile or upper or
we got down a point. Tenancy agreement, tenant. Tenancy agreement, name ebe landlord game and tenant game. Tenant need a lot of dinner. I didn't declare. He may have yame. But other tenant. In most cases, on our bokari, every year go, but it will boom. Then I've got a wedding went to a guy marching on I on a manner. Kadi kan jalu, it feels like what I'm now ide to go man never go to go. Now, this solution you told money to give away to me. Man, also tells it in only game when you get me or maybe in the dog court, you can't. So it's not advisable. This is not the told man. I think we got down a point. Tenancy agreement, tenant. Tenancy agreement.
Well, I apologize because those clips are not very sharp, and we're going to improve on that next time. But however, I can get at what they said. The woman was talking about tenants who refuse to pay, only having it in mind of going to court. At the end of the day, they may leave the house without paying their house rent. And the other one is saying people who, that is the man there who is an estate manager. He's talking about suing the tenants from behind. Larry Wangu, a lot of times the lawyers and estate manager, they connive and they secretly sue the tenants without the tenant knowing it, only for him to be packed out one day. So I want us to start from there. How good is that?
It is a wrong procedure, and it amounts to a wrong to the tenant, a breach of his own fundamental right. He is entitled to be aware. That is the reason why the law provides that if you intend to sue a tenant, you must serve the tenant with a notice. And that notice, the law also said it must be personal, except in a situation where the tenant cannot be seen or where he has relocated, a reasonable search for him has been made, and you cannot find him, then the law will now permit you to paste the set notice at the rented apartment, and it could also be deemed as proper service. So, but there are situations where you serve notices and they still refuse to come to court. It happens on a number of cases, where tenants choose not to come to court. They will also choose not to pay rent. Some of these things they talk in beer parlors. They tell you, since you have sued me, I will no longer pay rent. Things like that, not knowing the provisions of the law. When you are sued, it is also your fundamental right to go and defend yourself and say how it is and how it was and what transacted between you and the landlord and the extent to which you are owing. So long as the landlord have fulfilled all the requirements in law, he has issued you with a notice to quit, issued you with owner's intention to recover possession, and he has now filed a summon, a plaint against you in the law court. The court, at the first mentioning, because the bailiff will definitely swear to an affidavit of service, and it will be in the court's file. And when these are done, the court will look at it and say, issue the person another notice notifying him of the next adjourned date. If you fail to turn out, the court cannot wait for you forever. The court will do justice. So that is just the position.
I think I have two property lawyers into this program. I want to ask you, Ozioma, people who are sue to court, they refuse going to court, they refuse paying their house rent. Is there any way the law can clamp on such tenants? Who tells the landlord, you have dragged me to court, therefore I won't pay my house rent again. He keeps on, he continues living in that premise or that apartment. How does the law clamp on such tenants?
Like he said, once you have been served with the notice to quit and you have been served with the intention to come to court and recover possession, and then the landlord proceeds to court to lay some claims against you, and you've refused or failed to answer to the claims, to come to court and answer to the claims, the court, there's something the court calls foreclosure. The court will foreclose you. That means you are no longer part of that proceedings at that point. The other party will go ahead to defend or to make his case known to the court, and then the court will look at the evidence before him, both the receipts of payments, that is where the tenant paid last, when did he pay last, and how did he make his payments, and then all those, see that the notices has been served on him, there is proof of service before the court, and then the court will also look at if there is an agreement between the tenant, look at all the evidence, and then make his judgment. Once the court proclaims his judgment on that matter, giving the landlord the possession to his property, and then telling him to go ahead and recover his money, that is, the tenant at that point is binding by the judgment of the court. The landlord now he reclaims his property back. That is by going.
What means?
He will go and enforce the judgment of the court.
Through the police, with the police?
No, he will use the court's bailiffs. There is what they call writ of fife. That is the movable properties of the tenant. They will attach it. They will now go and get the movable properties of the tenant in order to recover both what the tenant was owing the landlord and then to recover possession of the premises.
So, Councillor Larry, how possible is this? The court bailiffs, are they strong enough like the police to make such recovery?
Yes, the law actually gives them that right. But where they feel that the tenant or there might be resistance or a breakdown of law and order, the police can be assigned to them to do so. because in the judgment, there will be what we call arrears of rent claim, and then what we call means profit, which arrears of rent has to do with the ones you were owing before the notice was served on you. And once that notice terminates, we regard those ones as arrears of rent. And then from the moment that notice terminates, all other money you are owing, even if you're there 20 years, the court will calculate all of them. They will go into means profit. But when the court wants to award, the court does not separate both of them. It merges them and award that the landlord is entitled to so. You understand? Calculate the months from the ones you were in arrears of rent and the ones you were, the ones that fall within the means profit, and the court will now pronounce its judgment, giving you title. But we must always bear in mind, like that procedure I was talking about, there are courts that have jurisdiction to also hear these matters, like magistrate court and high court. In some states, like in Lagos, you find out that it is the rent tribunal and magistrate court has jurisdiction. Not necessarily they were divested of jurisdiction in possession matters, that is living accommodations, as the case may be. But down here, our customary courts do not have right to recovery of possessions. They can only maybe what we call arrears of rent. You can file a claim in a magistrate court just for arrears of rent, but they cannot go into the recovery because the law does not give them that right.
Can we look at the legal requirements of a house rent receipt? Is it because if you go to the market where they sell papers, they also issue receipt? And what if a tenant or a landlord connives with his lawyer to give a receipt that does not have the legal condiments of what the receipt should be, as regards tenancy receipt or things like that? So the question goes, what are the legal requirements of a house rent receipt to a tenant by the landlord? Councillor Zema.
The legal requirements of a receipt, rent receipt. One, your name must be on the receipt, the name of the tenant, and ensure that the name of the landlord is on the receipt also. Then ensure that the date which you made the payment is on the said receipt. The amount which you paid. What is the property? What property is the rent for? That is, are you living in a 2-bedroom apartment or are you living in a duplex? It must be written. And then it must be stated that this is the duration of which the rent it covers. This is within the period of March, January to March, or is for a year. And then ensure that the person that receives that money from you appends his signature on that receipt. His signature must be on that receipt.
Chief Larry, what do you have to say about this?
Actually, it's merely an acknowledgement. A piece of paper can also do that. The most important thing is to acknowledge money received. State the purpose for which the money has been collected.
The piece of paper will bear both signatures of the landlord and tenant.
Yes. The most important thing is to state the amount, just like my colleague has said, the property you are paying for, a room or a flat, where the property is situated.
Let's take this caller. Hello? 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 Yeah, talk louder. We're not hearing you clear. Hello? Good evening. Your name and location? I've had Aguleri. What's your name? We can't hear you. There seems to be a network problem. Are you getting the voice clear?
You said it's non-so.
Non-so from Aguleri. Non-so from Aguleri. Okay. Ask your question, non-so from Aguleri.
Okay, they may have.
Okay, Larry, I think he's talking about the landlord's refusal or negligence of embarking on some necessary repairs, only for them to be very sharp at increasing house rent, undermining the repairs which the tenants may have earlier requested. So on this kind of situation,
actually, it's part of the right that the tenant has, which...
wait, let's know if we can still get this one clear. Hello? Hello? Hello, your name and location? Yeah, your name and location. Get that far in ABC. What to volume TV? Please, you may have to call us back, but then in the process, tune down the volume of your TV sets so that we can hear you clearly. The topic remains landlord and tenants' rights in Nigeria. And I have two lawyers here doing justice to the topic, landlord and tenant rights in Nigeria. So let's know if this caller we can get him. Hello? Hello? Hello. So now the issue is landlord's negligence of embarking on repairs, only very sharp at increasing the house rent. It's a violation if there is an agreement in place. So how about that, Barrister Lariwango?
The law also provides, it is also part of the right of the tenant, because landlord cannot indiscriminately, without basis, without recourse to certain...
Please, can we get this caller? Hello? Hello? Hello?
Hello?
Yeah, tune down the volume of your TV set. Tune down the volume of your TV sets. You may have to call back. Like I earlier said, always tune down the volume of your TV set so that we can hear you clear. Okay, go ahead.
And goes ahead to increase the rent. When he does so, the tenants can challenge such an increment because it is unreasonable. And part of the grounds upon which they can challenge this increment, arbitrary increment, is what the caller has actually pointed out. A house that is dilapidated, a house that is not tenantable, a house that is not in good habitable condition, and you are increasing rent. So the law will ask the landlord, effect repair to the house, let it be tenantable. And there are so many procedures.
What would the law do this when the tenant will have refused paying for the house rent?
Yes, they can canvass that, or the tenant can lay a complaint to health officers, because sometimes tenants do not know their right, and the health officers will persuade or enforce that or ensure that the landlord puts the place in order in a tenantable.
Okay, Barrister Ozoma, what's your position?
I think the tenant also has a right. He can sue the landlord for damages, whereby the house is dilapidated. Do you know the tenant is suffering some kind of health hazards, and then you're also increasing the rent, allowing him to be uncomfortable in the apartment whereby he paid for. The tenant can sue you for damages, and he can claim that damages against the landlord.
Okay, Larry, we have two types of landlords. Some of them have failed business. Some of them, their business still thrives. And those that have failed business, they rely on their house rent as everything about their existence. And these are the kind of people that increases house rent every time without repair. In such a situation, does the person lose the position of being a landlord?
He still remains a landlord.
Because he will be dragged to court one day over refusal of repair of the premises. He only collects rents and is very clever at hearing when other landlords may have increased their rent over an old house. And when he sees where a new building is erected and the rentage is 25,000, he also increases his own to 25,000. where there is no repair. So what do you have to say about that?
My take is that landlords should also be responsible to their responsibilities. A house you built maybe 30, 40 years ago. There are requirements that over the years, you need to improve on some of the facilities that are there. For instance, like the toilet equipment, some of them over the years they will turn black in color and things like that. It is advisable that you effect those repairs in order to attract people who can pay you your rent as at when due. Because when you refuse to do that, people who can pay you your rent as at when due might not rent that apartment. People who will enter into your apartment will be people who, whenever, however, and then you will see that you will suffer so many problems with them. Okay,
thank you very much, there is Tinjua. Well, you've had it, but we are coming back with part 2 of this program, and it's going to contain a vast size of vox pop. We really need to go out and sample people's opinion, because I know this issue of landlord-tenants problem is all over the place. As a result, we are going to have part 2 of this program, and so at this juncture, dear esteemed viewer, this is where we call it a day in our today's edition of Citizens and the Law. The topic has been landlord and tenant rights in Nigeria. I want to express my sincere gratitude to the 2 legal personalities here in the studio, starting from Barrister Ozioma Okonkwo. Thank you very much for coming. And then Barrister Larry Emeka Wangu, you've been wonderful and attending this program and making it look meaningful. Thank you very much for coming also.
Thank you, presenter.
And I am the presenter, Jude Mascotte Biago. I'm saying a very big thank you, dear esteemed viewer, to you all. We are coming back next week in another